Welcome to Shenkman Education. My name is Marty Shenkman, and we're going to talk about dispositive plans for married couples. What do you do? What might you do? What might you want to do in terms of your will, or if you use a revocable trust plan? The concepts I'm going to talk about work whether in a will or a revocable trust. I kind of like revocable trust. I have it for my family. I think it's a great tool, not just for avoiding probate, but for managing assets during aging and disability, and it's something everyone should think about, not our topic. I'm going to focus just on how do you leave assets to your spouse? Well, golly, the simple thing to do is what they call in the legal profession an I love you will. I love you, here's all my assets. In other words, outright, no trust, no planning. That is rarely, not 100%, but rarely appropriate. Why? Because if you leave assets outright to anybody, if they get remarried, if they get sued, what's going to happen? A better approach is to leave them in trust. What kind of trust? The best trust for many people is a simple marital trust called a qualified terminable interest property, QTIP trust. In that type of trust, your spouse has to get income at least annually. It could be quarterly, it could be monthly. So you know you're getting a cash flow to your spouse. And one of the benefits under current law, but it changes all the time, be mindful the laws change all the time, is that on your spouse's later death, the assets get a basis step up. So if she bought a particular stock in that trust, or you held it and bequeathed it to her, and you paid $10 for it, and now it's $1,000 a share. I wish I had that problem, right? On her death, it's included in her estate, and the basis is increased from $10 to $1,000. There's no capital gain when it's sold. So QTIP is good asset protection, good protection from remarriage, protects your spouse with a trust structure, named successor trustees if he or she is later incapacitated or has cognitive issues or dementia. The problem to be mindful of, there's already proposals, and there have been proposals, and depending when you watch this, maybe the law will have already changed, to lower the exemption from 15 million inflation adjusted to much lower numbers, 3 million, 5 million, whatever. So if you put assets in just a marital trust and they're all in your surviving spouse's estate, you may end up triggering a state estate tax. States have lower exemption amounts, like a couple $1 million. So give this a mechanism, and there's two I'm going to tell you about real quick, to shift assets from the QTIP or marital trust, where they will be included in the estate for the basis step up, which could be good, but if it looks like the law has changed or the law has changed, your spouse can be given the right to disclaim, saying, I don't want these dollars, and the dollars, or the amount she says he says that she doesn't want, go into what's called a family trust, or credit shelter trust, or a bypass trust. It uses all those names. And what that does is those assets are now outside your survivor's estate, spouse's estate, and they use some of your exemption on your first death. That's a way to safeguard assets. So let's say there's a $15 million exemption and you die, but we're worried the exemption amounts or the ability to use a deceased spouse's exemption, it's called portability, DSUE, D-S-U-E, deceased spouse unused exemption, may change. There's proposals now to change that. The law is always going to change, and anytime there's a change in Washington, there'll be a change in the tax law. Nothing seems permanent in Washington when it comes to tax law. It's permanent until they change it. So your spouse can disclaim or say, I don't want, renounce some of the assets, put them into that trust, use your exemption in case there's fear the law will change. And in that way, the exemption, the ability to transfer money free of estate tax for you, is preserved for your ultimate heirs after your spouse. The next thing is you can use something, and it's more complicated, called the Clayton QTIP, C-L-A-Y-T-O-N, Clayton QTIP, in which an independent person, it shouldn't be a spouse, can determine how much the marital deduction is, thereby shifting the difference into this credit shelter, bypass, or family type trust to use exemption. It's more complicated, it takes a little more cost in drafting. The advantage of the Clayton approach, and this gets too technical for us to get into, is that your surviving spouse can have what's called a power of appointment to direct where the assets of that credit shelter, bypass, or family trust go on his or her, their later death. So it's a little more flexible, a little more complicated. The key point is, don't give assets outright, they're not protected. You could even give it into a simple trust where your spouse is the only trustee. It's still some measure of protection. For more wealthy people, it gives you the ability to make a reverse GST QTIP election. Talk to your advisors about that. For the average person, use a marital trust. It protects the assets. Even for a moderate wealth person, consider building in either a disclaimer, which is fairly simple, or a Clayton QTIP, because the laws may change. Thank you for joining us. Please keep in mind all video clips, including this one, are for educational purposes only. Don't take any legal or other action without appropriate professional guidance. For more information, see it's like a parade behind me, www.shenkmaneducation.com. Thank you for joining me, and I hope this was of some practical help.